If you applied for a Canadian study permit and your application was refused, what are your options? Do you have options? Is it the end of the road for you? Probably not. You do have options. However, before you explore your options, one of the first things you want to do is try to understand the reason behind the refusal. And then once you're clear on what the real reasons are, then you can plot your path forward. Hi there, welcome back. My name is Donovan Francis. I'm a Canadian immigration lawyer at Goose Law Immigration, and we help businesses with their employees' work permit applications and save all of them the hassle, the legal hassle associated with these kinds of applications. In this video, I wanted to talk to applicants for Canadian study permits whose applications have been refused. If you applied for a Canadian study permit, there is no guarantee that your application is going to be approved. In fact, generally speaking, based on the statistics coming out of the immigration authorities, the Canadian immigration authorities, the overall refusal rate of study permit applications appears to be in and around 40%. Right? So that's a significant percentage of study permit applications that are actually refused. And so if your application is refused, what are your options? Well, the first thing we like to tell our clients is that before you try to figure out what option is going to be the best option for you, you want to have a clear understanding as to the reasons for the refusal. Okay? If you don't know the reason for the original refusal, then making a decision on, what avenue you're going to take to try to get your application approved is really going to be an exercise in futility. It's like shooting in the dark. You really won't know what issue you're trying to fix. So the first thing you want to do is to try to get and understand the real reasons for the refusal of the application. Now, when an application is refused, the immigration authorities will send you a refusal letter. And the refusal letter will give you what it claims to be the reasons for the refusal. But in truth, those are really just some generic responses that are provided on all of these letters, right? And those responses don't give you a detailed, personalized, application-specific explanation for why your application in particular was refused. However, there is a way to understand the reasons behind the refusal, right? You are able to apply for the office's written notes, right? But those written notes are not provided to you at the time when the application is refused. In fact, previously, it was not at all possible for anybody to get those notes. But for a case that happened at Canada's Supreme Court years ago, a case called R.V. Baker. And in that case, there was a woman whose immigration matter was before the immigration authorities, and the immigration officer made a decision to refuse this woman's application, but did not provide her with any reasons for the refusal. And so that was challenged. And the Supreme Court of Canada eventually ruled that if there is a decision on an application such as an immigration application, then at the very least, the applicants should be allowed an opportunity to understand what the reasons for the refusal are. And so thanks to that case, you are able to get access to those notes. Typically, we make a request through what's called an ATIP request, an access to information and privacy request. And by doing that, we then get access to the actual notes, the actual reasons for your specific application being refused. And when we have those reasons, we're able to go through and try to get a clear-cut understanding of what was in the officer's mind at the point in time when they made the refusal. And when we're clear on that, we then make a decision as to how we want to approach your matter. Are we going to refile given that there were obvious gaps in the initial application? Or is it a situation where we should seek a reconsideration, because the officer may have overlooked something and so on? Or is it a matter that needs to be appealed through what's called a judicial review, in which case we have to look at timing, how much time do you have left? Out of the 60 days allowed to people applying from outside of Canada, how many days do you have left? Is it even feasible to do a judicial review of the decision? But the bottom line is that all of these decisions will have to be guided by the ultimate reason behind the refusal of your initial application. And so that is going to be a crucial factor to bear in mind if your application for a study permit in Canada has been refused. All right, I hope you found value from this. As always, remember to like our videos so others will see more videos like this. Subscribe to our channel and check us out on go.gooselaw.com. Thanks. See you again.